7 o'clock. We are going to call the meeting to order. Jamie? I'm sorry, could you do roll call?
Yes. Blackburn.
Present.
Jeroni.
Here.
Hageman.
Here.
Howard.
Here.
Mishigian.
Here.
McAlexander.
Here.
Miller.
Here.
Thank you. Next is the approval of the agenda. Is there a motion?
I make a motion to approve the agenda.
Second.
Any discussion? All in favor?
Aye.
Any opposed? Motion passes. Next is the approval of the meeting minutes from November 25th, 2024, which was our last ZBA meeting. Is there a motion?
Move to we accept the minutes as stated.
Second?
I second.
Any discussion? All in favor?
Aye.
Any opposed? Motion passes. Next is public comment, and this will be for anything not pertaining to what's on the agenda, so you'll have a chance during the public hearing to comment if you're here to speak on that. But if there's anybody that wants to speak on anything else, please step to the podium. Seeing no comment, we will move on to case 2025-01, which pertains to 30850 and 30900 Telegraph Road. Do you want to do your presentation?
Sure.
Yeah. So we have our planner, Jill, here today. Some of you may not have met her yet. She's here. She works with Eric. And she just has a quick presentation just to kind of get everybody back up to speed on the ZBA meetings, since for some of you it's your first time going through it. So,
Good evening. Thank you. It's so nice to be with you all. As was mentioned, I am one of the city's planning, or the village's planning consultants. Have been on your team in that capacity since, well, probably since 2008, 9, 10, when I joined Dave Birchler with Birchler Arroyo. Over the years, we transitioned. We merged in with Giffords Webster back in 2016, and I now run our planning team. And Eric has been part of this planning process as well. So I have some history with the village that is really nice to be back this evening with you and review with you some of the training slides, just to give you a refresher. And I know it's a little bit awkward, as we don't normally do it as part of an agenda item. But in light of the fact that for some of you this is your first meeting in that role as the ZBA, we thought it would be a really good time to give you a couple of tips and just to kind of understand a little bit. And we can do a much more deeper presentation for you, should that be necessary, at your convenience in the future. So we just kind of want to go over who does what, and then we may not get to the good meeting practices and other things, but I think it's really helpful to have this kind of background. So Village Council, you know your role. Right, your role is to establish the zoning and the land use legislation. You're serving as the final approval authority for rezonings and plan unit developments. It's been a while since I think you've had some of those, but that is part of your duty. Generally, zoning or land use issues are presented to you after recommendation from the Planning Commission. And then here we have you serving as the ZBA. And some communities have their legislative body serving as their ZBA, and others have a separate body. Tends to be smaller communities that have a double serving board here. But it's important to kind of go back a step too and think about what the Planning Commission does. So the Planning Commission's job is to create, maintain, and update the master plan for the village. They review development review requests from applicants, site plans, special land use. They'll look at rezonings, they'll look at plan unit developments. They also may initiate changes to the zoning map or to the zoning ordinance that are consistent with the master plan. So you've got a current master plan that was adopted in 2021. Next year will be time for your 5-year review. Doesn't mean you have to change anything, but it's good practice to get in there and take a look and make sure everything is up to date. So yours is pretty up to date. We just did it in 2021. And then the Zoning Board of Appeals. You have 3 roles that you are enabled to do through your ordinances. You can give variances from standards of the zoning ordinance themselves. You can do interpretations of the zoning map or the ordinance, and you can provide appeals of other decisions. So appeals of an administrative decision or the Planning Commission, and also looking at nonconformity. properties. So the ZBA has an important role in looking at the zoning ordinance standards as they apply to specific properties, as well as interpretation and then appeals. And when you look at appeals, it's really about understanding what standards are being measured. So you also have staff and you have consultants, and we do a lot of the other work that is maybe more behind the scenes in terms of process, and that's just helpful background to have. And then you have legal counsel as well. They answer legal questions. They don't typically give you policy, but they may share knowledge that is legal or maybe not even strictly legal, but just good practices and best practices. So we've got two statutory authorities in Michigan for creating the Planning Commission and the Zoning Board of Appeals. And those are the Michigan Planning Enabling Act and the Michigan Zoning Enabling Act. And basically that gives communities the ability to create their long-range plans, and it also gives you the ability to create zoning standards to guide and to bind property owners to. And if you have the zoning, you have to have a plan. And so those two things are intended to be in alignment with each other. And so when we're preparing a zoning ordinance, again, we have the ZEA that provides us that legal authority to do it. The Planning Commission drafts the ordinance text and the map, and again, that's based on the master plan. There's public hearing prior to recommendation, and then adoption by the village council. And the same process is followed for all map amendments as well. So it's helpful to have this background and understanding where we have our zoning standards, and those are coming from our master plan. So our master plan is long range, providing us guidance, helping us set policy. The zoning ordinance is immediate, it's regulatory, and it's enforced. And so we have a little graphic that helps walk you through the zoning ordinance adoption process. And this is really there by way of helping you understand the process by which ordinances are created and subsequently amended. Just to say that there's a lot of steps and there's a lot of players involved in that process. The same process for zoning amendments and rezoning of property, which is the same as a zoning map amendment. So you are allowed to do dimensional variance requests, or allowed to consider those. Your ordinance has criteria for granting those variances, and your analysis, and when you're acting in that role as a ZBA, should be framed by those criteria, and that's in section 7.1.5. We always highlight that only the minimum variance minimum variance needed to provide substantial justice should be granted. So sometimes if you have an applicant in there and they're asking you for a 10-foot side variance, for example, you might say, is there any way that we can make this more in conformance with the ordinance? Maybe they can come down to an 8-foot or a 7-foot and achieve the same things. But in general, the ZBA really should grant few variances. And if you do find, as you go forward, that you're consistently looking at requests for similar situations, that might suggest that the zoning ordinance needs to be updated, and in which case the ZBA, the Village Council, would ask the Planning Commission to do some study and assess whether some changes might be needed to help alleviate the requests that are being asked. So when we have those dimensional variance requests, we have things that we're looking at, unique circumstances applying to the property. So we might ask, how is this property different from others? Not adversely affecting adjacent properties. Is there a harm if we allow this to go through? The need for the variance is not self-created. Did the applicant take any action that made the variance necessary? And then again, the minimum necessary. When we're still looking at dimensional variances, we're asking, is the request consistent with the character of the area? Would the variance convey a special privilege to this property owner that others would be denied? Is the variance the minimum necessary, and are there alternatives which would minimize or eliminate the need for a variance? So those are the kinds of things that we're working towards. For use variances, these are really more substantial kinds of variances. So this says that when we're looking at these, a property cannot be used for any of the uses permitted in the district in which it's located. This means that none of the uses, whether that's a by right use or a special use permit, would allow a reasonable economic return on the use of the property. The plight of the property owner is due to unique circumstances particular to the property and not due general neighborhood conditions. Proposed use not alter the essential character of the area, and the problem was not self-created. So those are the areas in which you are allowed to look at variances. But we also think it's helpful, because these are things that we hear all the time from CBAs, not yours, but around the area. We would say, well, it's expensive for the applicant to follow the ordinance. Okay, it's unfortunate. In some cases it is. No one objected. We hear that one quite a bit if no one comes to a meeting. The applicant already built it, which is really unfortunate. And we'd never like to see that. And I worked in a community where many, many, many years ago, an applicant built something and the ZBA denied it, and it was a front porch addition, they had to rip it off. And nobody left that meeting feeling good. We trust the applicant will do a good job. We like it when we have applicants that we know that come before us and ask us, and where we can't be creating special privileges for those folks where we wouldn't necessarily do that. The applicant really needs to get started soon, and they didn't know about the standard. So these are all things that we hear all the time. Those are things that you will hear over time as you go forward, and you need to kind of put those things aside and focus back on those other things that were important. I don't know that I need to get into the map interpretations or administrative appeals, with only to say that, I'm going to skip ahead. We've got open meetings. I do think it's helpful that we, again, look at making motions. Making motions are very important part of the record. And as the ZBA, your job is to build a good record. So as you are making discussions and you're making findings, you're going to be thinking of the findings of fact of the case. And so you'll have those in mind as you make your motions. Whether you are approving a motion or motion to approve a variance request or to deny a variance request, you want to make sure that you're very detailed with respect to the description, the action taken. If there's any conditions there, we want to make sure that we're clear about those. The reasons for the action taken, which is particularly important for denials, any reference to staff reports when it's appropriate. When you have conditions, one thing that's not up there, but also if you have a condition, who's going to enforce that condition? So it might be the planning consultant, it might be the village manager, it could be a different party, but we want to make sure that we articulate that in our motions. And then making sure everyone's clear on the motion before there's voting, and only obviously one motion at a time. You are able to also attach conditions as long as they're reasonable, designed to protect natural resources, health, safety, and welfare, social and economic well-being of users, the standard things that we have, and of course related to the valid exercise of police power, necessary to meet the intent and purpose of the ordinance. So it's not random conditions that we're assigning to this, it's things that we are assigning that are going to alleviate a specific concern and be related to the ordinances that are before you. And I think with that, you can always also postponing action. If there's an incomplete application, extensive changes are needed, the applicant requests that, you need a motion to postpone that. We try to make sure that you have all the information that you need before you have your meeting so that when you're here, you're able to make a decision. But if you find that the questions come up that the applicant's not able to address or you don't feel comfortable with that, there is no need for you to rush into making a decision. As long as you're being reasonable with the information that you're asking for and you're specific and the applicant is clear and you put back, like, when are you going to come back to meet with us? So if it's next month, you need 2 weeks to provide this information, great, and then you can have that. So I just wanted to make that kind of clear. Just remember that as the ZBA, you are wearing a different hat than you are when you're a village council person. Those duties are unique. It's often in conflict with residents and businesses who don't understand the regulations, or maybe even think that the regulations should be changed. You establish and use your rules of procedure. You've got bylaws. Read the ordinance, know what you have. Ask questions when you need more information. Never hesitate to ask anybody questions during your proceedings. And then just know that the ZBA decisions really directly impact the community's planning and zoning, and so those are just things to be mindful of as we go forward. So I'm going to cut it right there because I think that's our time.
And if I may add a few things.
Sure.
A couple of things to be thoughtful of in line with making of the motion. So when you are considering a variance or an interpretation, the Supreme Court has said that each and every element of the 5 things that you have to look at under your ordinance, each and every one needs to be examined, analyzed, and articulated on the record. So that if there is an appeal of your decision, so whether you grant or you deny, and the applicant's right to appeal is to the circuit court, the court has said very clearly that every single one of those things must be analyzed on the record. Otherwise, the record's incomplete. They'll send it back down to you to do it again. So when you go forward, make sure that each of those are discussed at length and then tie it into the motion as Jill has described. we are granting for this reason, or I make a motion to grant because I find that or deny because there's not a hardship that was maybe self-created, etc. And we can help you with that as time goes on. The other thing you want to be thoughtful of is that each and every decision you make does have precedential value to the next decision that you make. And I agree with Jill that variances should not be given out easily, lightly, or quickly. If there are repeated requests for a variance, or there's something out there that screams that something needs to change it, not the variance, because you are creating a precedent, and you will hear it after the next applicant. You did it for that person, you have to do it for me. And it should be done because of the merits and the facts of each individual case with the analysis of each of the 5 elements in your ordinance. Thanks. I just wanted to throw that in.
That's great.
If I could.
Thank you. Is there anything else?
No.
No? Okay. So, I'm going to open the public hearing.
Yes, you would open the public hearing.
Isn't it a valid presentation?
You have to open the public presentation. So for members of the audience, you want me to do this? Yes. So members of the audience who are part of the appellant team, which is I think 99% of you, the way this works in an appeal, there's a public hearing. The public hearing is opened by the chair of the BZA. Once that occurs, the applicant has the opportunity to make a presentation. Staff can make a presentation, and then it's time for commentary from the public. Once the public has ceased its commentary, the public hearing then is closed, and then it comes back to the BZA for its analysis, questions, comments, and ultimate motion and decision. I will also throw in there that it is 7:18. You have a regular meeting that starts at 7:30. You have an obligation to start that meeting at 7:30. I've had an opportunity to speak to counsel for the applicant. They are aware that there's no way this is going to go past 7:29. And they know that and they understand that. They're not angry, they're not upset. They are aware that you have another job to do tonight. Thank you.
Okay. With that being said, I'm going to open the public hearing at 7:18 p.m. And we are ready for the presentation.
Thank you, members of the Board of Zoning Appeals. My name is Richard Rassel. I'm with the law firm Williams, Wright & Plunkett, Birmingham, 380 North Old Woodward. I would just like to introduce briefly for you the applicant team. I represent Market Square of Bingham Farms, of course. That's the applicant noted on your application package, and we noted our letter of July 8th. John Carmo and his family are here this evening because we understand, and talking to Mary did reach me today, we have some significant time restraints, so we're gonna, I think we're gonna pivot for a moment here in a second, but I want to introduce everyone because this was the plan for everybody to be here tonight, to answer questions, to try to show how serious the Carmo family that owns the Market Square brand and the Market Fresh brand was about locating here in your great community. So John Carmo, Diane Carmo, and their children, John, Lake, daughters. Yeah, so we've got quite a few folks here. This is a family business, that's why. Market Square, Birmingham, Market Square in West Bloomfield, Market Fresh on Southfield Road in the village of Beverly Hills, your adjoining neighbor. So I understand the time constraint that we're dealing with. There's no way that we're going to be able to make a full presentation in connection with what we feel is a very meritorious use variance request for this Market Square to be located in your C1 district, which obviously the overriding argument is the property cannot be used as zoned for the very limited permissible purposes in that district. On Telegraph and the 13, literally just to the west of here, everybody knows what property we're talking about. There perhaps maybe another way in which this body may ultimately consider a different route for Market Square. We certainly don't this evening, understanding that you have other business to attend to very shortly. We certainly are not in a position this evening to withdraw our use variance request. It's meritorious. We feel very strongly about it. I feel that the site in this unique location and unique shape and unique economic circumstances that we described in detail in our letter all weigh heavily in favor of a use variance, even under the strict standards under Michigan law. We feel we do meet all of the ordinance standards, et cetera, et cetera. We feel very strongly about our application, and we were prepared to go all the way through a full presentation tonight and have you folks ask questions of the Carmels and myself. And for Mr. Soroki, oh, I'm sorry, Victor. I apologize in my haste to get on with making sure that I wasn't going to overlap your deadline. I forgot our very good friend Victor Soroki of the Soroki architecture firm in Birmingham. Victor is not only the architect of record for this project. Victor's designed and done all of the market squares, both exterior, interior, both for the Carmel family. But I think other businesses as well, correct, Victor? So Victor, everybody knows Victor and his family and the business reputation. So, except for myself, John decided to bring the A-team in on this project. But I think the idea is the family is committed to be at this location. And is committed to working with the village to make that happen. This is a very great opportunity for the village to meet what your master plan calls for at that location, with a bit of permissiveness with regard to specialty grocery retail. We can handle all of the concerns. We think the site's big enough for this location. We can park it perfectly. We can landscape it very well. It'll be beautifully designed by Victor and his team. This is a great opportunity. We consider this to be a great opportunity to be in this community, on the right location, on Telegraph 13, and figure out a way to make this work. So we're committed to that. I'd like to just ask that we move this particular use variance request to perhaps your next meeting, if that's possible, or maybe if there's a reason to move it even from then. And then we'll continue to work with your great administrative staff, who's been very accommodating and pleasant with us, and Jill and Mary, and try to figure out if perhaps there's another route in the permissible uses in the C1, or if ultimately use variance request is the best route to fully make our presentation to try to get to the finish line and to remain committed. I do have one very important thing to note. This governmental body is not always interested in private concerns. The property owner, we are not the owner. We are under contract to buy this property. The property owner is very anxious to get us to the finish line, as most people are in business. We are operating in a very strict contractual timeline with the seller of the property, and that's not necessarily your concern, but we'd ask for whatever consideration you could give us in helping us stay on your agendas, if you will. Stay on your front burner if possible. We ask only that because we think this is a great potential opportunity for the village and for the Carmel family to try to realize their fourth location in a wonderful community. Does anybody have a question for me that I can answer, or Mr. Soroki or Mr. Carmel before your regular meeting jumps in?
You're in a
public comment
It's public first
time.
before these
Yeah.
guys.
Okay. Well, when you get to that phase, I'm here.
Thank you. Thank you. It is time now for public comment, so that means it's time for the public to speak. If anybody wants to say anything, now would be your time to step to the podium.
No, we just wondering, we got the letter in the mail today, and we're just wondering what's going on, and now we understand Market Square restaurant, or grocery store is being discussed for occupancy on those two plots that are, so that's all we know.
Okay, well, we
That's why
can't-
we're here.
Unfortunately, we can't go back and forth right now, but I do need your name and your address.
Frank Selgren, Christy McKenzie, 24118 Bingham Point Drive.
Thank you.
So then, Madam Chair, I think the appropriate thing to do is postpone the continuation of the public hearing to a date certain. So the public hearing is still going, so the notice requirements are still in effect, and it would be to the date certain. You can choose your next meeting or the meeting after that. You may choose which one is appropriate for the board. And you would need a motion then to postpone and continuation of the public hearing.
And is there a suggestion as to
As
getting
to
everything together, the date?
When is the next?
August 25th.
That sounds right. I got
Yeah,
that calendar in
Yeah,
front of
August
me.
25th.
Let's go ahead and do the August 25th, yeah. Yeah.
So I need to close the public hearing first.
I would leave it open. I would leave it open since there really hasn't been the full presentation. The applicant has not had the opportunity to persuade you on the 5 elements, and there may be other public that would like to weigh in. So I think don't close it.
Okay.
Do a continuation with a postponement to a date certain.
And that, yes, so postponement with a continuation.
So someone needs to make the motion.
Right.
I move to continue the public hearing and postpone the continuation of the public hearing to a date certain of August 25th, 2025 at, I would suggest, 6 o'clock instead of 7 o'clock. That would be one's motion if someone was interested in making it.
I'll do what she said.
Yeah, it was my husband thought I said it back then.
We have a first and a second. Is there any other discussion?
Was there an actual, because of my notes, was there an actual time included in the motion?
6 p.m.
6 o'clock. 6 p.m.
What was the date?
The next
The next meeting.
is the
Next council
25th.
20.
Any further discussion?
I do have a question. Might this be a case for a separate standalone meeting versus in front of our regular village meeting?
That is possible, but I think if you start at 6, an hour and a half probably should get you there.
I was just concerned about their
We'll have 1
timeline.
hour. Our meeting started at 7, so that'll give us only an hour.
Oh, I thought your meeting started at 7:30.
7.
I did 2 one night.
Oh,
So
and 5.
5:30.
they're 5:30.
So there was a motion on the table and it was seconded, so someone would have to make a friendly amendment to the motion to change the time to 5:30 PM. Is there that friendly amendment someone's making? a
Ditto.
motion?
I will
Friendly.
move that we amend the motion to 5:30 as opposed to 6.
I second.
And the maker of the original motion accepts that friendly
Yes.
amendment?
Any other discussion? All in favor?
Aye.
Aye.
Any opposed? Motion passes.
Is that good?
Yes.
That way then you guys get time to fully present. We have time to look over the stuff.
Thank you very much.
Okay.
Then we're gonna make you all come back again.
At least we could do is serve coffee and dessert. Thank you
Thank
very
you so much.
much.
Thank you for
Thank
coming.
you.
It's nice meeting you. Thank you.
Have a good meeting, everybody.
Thank you.
We're leaving.
Yeah, you guys have more fun than we're having. Put that on the record.
Good night.
So no.
Thanks.
Thank you.
We're gonna have.
Thank you for coming. We'll talk tomorrow. Okay.
I'm anxious to look at
Thank
the
you
big
all.
Possibly
plans.
questions that should have been asked of Mary. Do we still have to adjourn?
Yes.
ZBA?
I'm still going to adjourn,
Okay.
yes. So I need a motion to adjourn.
Move to adjourn.
Second.
Any discussion? All in favor?
Aye.
Any opposed? Motion passes. Meeting adjourned at 7:30 PM.